Congress does not have the power to fund stem cell research. How could the Founding Fathers ever conceived of such a thing as stem cell research back in 1787? And the answer is that they couldn't, and if they couldn't, they didn't. And if they didn't, then Congress doesn't. But Congress has. So that means that Congress must know that they have unlimited power. They must know they have the power to legislate in all cases whatsoever. So they must know that they should never tell the American people they have this unlimited power. So just pay your taxes, and pay your taxes, and pay your taxes, and pay your taxes. And just hope that they leave you enough money to live on. Because they have the power to tax everything that you earn. Because you voluntarily gave them that power. Thank you, Ben Franklin, for your words to deceive. Thank you, Founding Fathers, for the power to legislate in all cases whatsoever. Thank you, Masons, Order of the Quest, and of the Illuminati, for your ability to conceal the truth from us. I would now like to continue the idea that the Constitution was granted unlimited power to Congress. This is a rather poor quality photograph of Howard Freeman, who was, in my opinion, this nation's greatest constitutional authority. I had the pleasure of having met him several times out on the lecture circuit or at a summer camp. He once came to my hometown of Tucson to speak to a club that I was a member of, and his host invited me to his home to meet with other guests and talk with Mr. Freeman. He told us two stories from his personal experience that I would like to retell now because they are extremely pertinent to the study of America's secret destiny. Mr. Freeman told us that he was asked to testify as an expert witness in the case of a friend of his who had stopped paying income taxes because he did not think he was legally obliged to do so. This friend of his was charged with willful failure to file. When Mr. Freeman was on the stand, he was asked to cite various Supreme Court decisions that provided the evidence that this defendant did not have to pay income taxes. Mr. Freeman said that he was elated that he was able to get these decisions into the court record. When Mr. Freeman completed his testimony and the trial had ended, the judge spoke to the jury. I don't know if that's the real judge or not, but that might have been, before they were dismissed to reach a verdict. The judge told the jury, "You are to completely ignore the testimony of Howard Freeman." Mr. Freeman was shocked, and he left the courtroom to meet with the judge as he was going into his office. He asked the judge, "By what authority do you overturn the standing decisions of the United States Supreme Court?" And the judge replied, "Those were old decisions prior to 1938. And Mr. Freeman said, "Those are standing decisions. They have not been overturned. I do not care how old they are. You have no right to overturn a standing decision of the United States Supreme Court in a lower district court." Mr. Freeman then asked the judge what had happened in 1938. The judge said that he had already told Mr. Freeman too much and that he wasn't going to tell him anymore. He ended their conversation by walking into the room so that Mr. Freeman could no longer question him. Mr. Freeman then went to a law library to see if he could find a Supreme Court decision dealing with this issue. And he found the Erie Railroad versus Tompkins case of the 1938 Supreme Court. For the purist who wants to read the case, it is found on page 64 of the October term 1937, Syllabus 304 U.S. Certiorari to the Circuit Court, I don't know how to pronounce that, Court of Appeals for the Second Circuit, number 367, argued January the 31st, 1938, decided April 25th, 1938, and there's the case on the right side of this screen. The case consists of 4 paragraphs in sequence, and the third one reads as follows. There is no federal general common law. And it now becomes important to discuss what the common law is, and I'll make it brief since I am not an expert on the subject. The simplest explanation of the common law is this: man is only guilty of harm if he damages another person's property or injures his person. Which means there is no damage unless someone or something is injured. The Constitution used to be this nation's common law, but according to this judge, the Supreme Court ruled that the Constitution was no longer the supreme law of the land. Mr. Freeman then told us that a short time later he met a retired state Supreme Court justice who told him that they needed to talk. When the two of them met, the judge told him that he was a retired state of Wyoming Supreme Court justice who had been appointed to that position while he was a federal judge in Wyoming. He then asked Mr. Freeman not to reveal his identity because he could, quote, get into a lot of trouble, end quote, by revealing too much. Mr. Freeman agreed that he would not ever reveal his name in any of his discussions of the proceedings in the courts of America. And the judge told him this story. In 1938, notice the year, 1938, all the higher judges, higher federal judges, the top attorneys and the U.S. attorneys were called into a secret meeting by President Franklin Roosevelt, who recalled to their attention that in 1933 he had suspended the redemption of our gold certificates in gold. This is a sample of a gold certificate. You will notice that America's money used to have a promise to redeem the paper certificate in gold with these words as shown in the red rectangle. This is to certify that there is on deposit in the Treasury of the United States of America $100 in gold, payable to the bearer on demand. What this means is that the possessor of a gold certificate could take it into a bank and request that that value shown on the certificate in gold, he could ask for it, and that the bank would provide the holder with that amount of gold on demand. But in 1933, President Roosevelt suspended this requirement to allegedly assist in controlling the after effects of the great stock market crash of 1929. In other words, the American people could no longer get their gold for their gold certificates. This was a contract of the United States government with the holder that they could obtain their gold for their certificate anytime they wanted. Notice that this phrase does not say subject to revocation on the whim of a president. America was revoking a standing contract by no longer honoring the terms of that contract. Roosevelt then went on to explain the international bankers who own America's national debt had declared that the suspension of the redemption clause on our money was an act of a bankrupt nation. The president was admitting that the nation was now totally owned by the international bankers. And as the new managers of this nation, they could set the rules and regulations under which we lived. Roosevelt was telling these judges that the international bankers had decided that they as judges could no longer adjudicate cases on the Constitution of the United States, the supreme law of the land. They were to use the Uniform Commercial Code as the new supreme law of this land, with one exception. Roosevelt told the judges and the attorneys that they had to take silent judicial notice of the fact that the Constitution was null and void and that we were living under a new set of laws called the Uniform Commercial Code. That meant, in language that only judges and presidents and attorneys understand, you cannot tell the dummies. You must use language that makes it sound like it is coming from a constitution, but it isn't. But whatever you do, never tell the people of America. And ever since 1938, they have succeeded with only a few exceptions. And to show you that, in my opinion, the current Congress knows they have the unlimited power of the grant to legislate in all cases whatsoever, and that they must not tell the American people that the Constitution is null and void. Let me illustrate the point by bringing up the case of Congresswoman Nancy Pelosi, the Speaker of the House. She was asked where she got the authority to even consider legislation that would remake the nation's healthcare system. And she answered, from the power to regulate interstate commerce. Now let me point out that Congress did grant that specific power in Article 1, Section 8, Clause 3 of the Constitution. It reads, Congress shall have the power to regulate commerce among the several states. But here is the question. If Congress has had the power since the Founding Fathers gave it to them, why did Congress wait until the year 2009, over 200 years later, to consider legislation to remake the healthcare system? Madison did say that the powers were few and defined, and I must admit the Commerce Clause words are not defined by the Constitution itself. However, Alexander Hamilton, in Federalist Paper number 22, did discuss what they meant by the phrase. He wrote, the interfering regulations of some states have given just cause of complaint to other states, and it is to be feared that examples of this nature, not restrained by a national control, meaning some sort of power being given to Congress to regulate interstate commerce, would be multiplied till they become injurious impediments to the intercourse between different states. Putting that language into today's terms, he meant Congress was giving the power to protect commerce between states when one state might be causing problems for shipments across their state borders. And now again I must ask, why did